Hello and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest today is Dwayne Kwaysee Wright, Visiting Assistant Professor of Law at Savannah Law School. We will discuss his scholarship on race-conscious admissions, especially his dissertation, An Instrumental Case Study of the Diversity Culture of a Predominantly White Law School. Welcome to the show, Dwayne.
Welcome. Thank you, Brian. Thank you for having me, Professor Fry. I've been a fan of the show almost since its inception, and I think you do a wonderful job, and I am blessed and privileged for you to have me on.
Well, thank you so much. It's really flattering for me to hear that, and I got to say, I really enjoyed reading your work, including your dissertation, which was a really fascinating, both theoretical and sort of empirical, qualitative study of diversity culture in a law school. And I was hoping we could start the conversation by you kind of laying the groundwork for the terms on which we can understand some of the issues that you're grappling with in your work. So you talk about race-conscious admissions. A lot of people often use the term like affirmative action as well. And I was wondering if you could talk about the relationship between those two concepts or ways of articulating similar concepts, and sort of also sort of the different perspectives on the nature of the problem or how to think about the problem that you outline in your paper.
Yeah, so no problem. Well, again, thank you for having me on. And I think where I probably best should start is by giving two premises in which this work, this particular dissertation, and my body of research began. The first premise for your listeners is the premise that racism still plays a part in America, and that if racism didn't play a part in the actual outcomes today of America, we wouldn't be having this conversation. The second premise from which you have to understand where the work goes through is what I call the problem of proxy. And the problem of proxy is one in which if you graduate from a Harvard, if you graduate from a Penn State, where I got my PhD, if you graduate from a University of Kentucky, Brian, where you are at, your outcomes are different than if you graduate from what some would call lesser schools. And if we didn't have the problem of proxy, there wouldn't be a need for this conversation we're having today. Mm-hmm. So two premises that I think your listeners need to understand, and we can argue about those, but where I come from in doing the work. So I wanted to make sure I made that clear up front.
Sure.
So the syllogism, so the logic flows for your listeners. To your question directly, though, affirmative action is one of the most contested policies, one of the most I was going to say misunderstood, but what I will say is incorrectly understood, and I'll explain the difference. One of the most incorrectly understood functions and policies in American life.
Okay.
So let's just go ahead and take the words, affirmative action. What does it mean to do affirmative action? Well, it means to affirmatively do something that's an action or a policy. And it comes from a set of policies that actually theoretically and conceptually go back to Reconstruction. So right after the Civil War, to place the formerly enslaved people into a better format. So historians will know about the Freedmen's Bureau. Some other people will know about federally funded HBCUs. These are all affirmative actions to give the former enslaved people the right to vote, the right to an education, et cetera, et cetera. What we know today as affirmative action, ironically enough, comes out of the mind of a conservative administration. It was the Nixon administration that first started doing affirmative policies to help African Americans who at this point were long since free from bondage. But the effects of not just the Civil War, but the Jim Crow era and everything that came after that, all the way into Brown versus Board of Ed and the Civil Rights Movement, were still in effect. And
Yeah.
what these were actions, affirmative, so not just not doing something, or not just negative law, which prevented the government from discriminating, or prevented private people, the 1964 Civil Rights Act, from discriminating, but affirmative actions, positive actions, to try to put these people who are American citizens into equal place.
Mm-hmm.
So you have to understand, that's what I say about affirmative action. Some of these, and these were first actually, the genesis of them comes from employment, making sure that if you're employing one person versus another, that you're not considering race. And the genesis of what we know as affirmative action comes from employment. Such cases as Wygant, such cases as Carson, such cases as Adirondack, which we won't talk about today because they don't affect higher ed specifically, but form the analysis of affirmative action.
Mm-hmm.
What I study specifically is what I would call a branch of affirmative action, which is race-conscious admissions.
Okay.
One type of action that a government entity, a state actor, might take to mitigate the effects of slavery, Jim Crow, et cetera, et cetera. And what race-conscious admissions is simply the use of race as a factor amongst other factors in determining who gets admitted to mostly a public school. And hopefully we'll get into the case that just gavelled down of the Harvard University, which actually applies to private schools. But when we think about race-conscious admissions, because the 14th Amendment applies mostly to state actors, we're thinking about public schools. So I make the distinction between the universe of affirmative actions, which could happen, and race-conscious admissions.
Okay, so I understand. So it's sort of a subset then of the concept, the broader concept of affirmative action.
Yes, sir.
Okay. So one thing that I thought was really helpful for me in your dissertation was the way you broke down sort of perspectives on race-conscious admission into sort of three categories. And I was wondering if you could just briefly describe those three categories and sort of where they're coming from.
Yes, so this found its way into a dissertation. It's what myself and another researcher who was an advisor to me on a master's thesis that I wrote, another JD PhD called Dr. Liliana Garces, who's out at the University of Texas, developed jointly. And it's a trichotomy of perspectives, not just on race-conscious admissions, but really on a perspective of how we advance in society on the race question in general. And this trichotomy has three buckets, if you would. The first bucket, let's call it color blindness. And what color blindness says, and before I may get criticized, I'm going to describe each of these concepts in the best light possible to the people that advocate the concepts. I'm not supporting, at this point, any concept.
Okay.
But color blindness basically says, in order to get beyond race, we need to simply and utterly stop using race. The best description of this that legal scholars might understand is Chief Justice Roberts' famous line in Parents Involved versus Public, the case Parents Involved, which has to do with public voluntary desegregation plans in Louisville and Seattle, in which Chief Justice Roberts said, the way to stop racial discrimination is to stop discrimination on the basis of race. Color blindness says that we should just simply stop using race. We should erase race from our thinking and from our dichotomy. We simply not use race any longer. Brian, when I look at you, I do not recognize you as a white person. When I look in the mirror, I do not recognize Dr. Wright as a black person. There is no race. Let's erase race out of existence in America. That's the concept of color blindness.
Okay.
The second point, and we're kind of going in a spectrum here. So the neutral point, the middle point, maybe not neutral, is race neutrality, right? And this concept, I will say, in the legal realm is birthed from the mind of our former Justice Kennedy. And it says that we need to make sure we're only using race when 100% race is necessary. So in order to use race as a government entity, you must prove to a fact finder, to the general public, if you're talking about politics, that you couldn't have gotten your end by using race in some other manner. There are many advocates of this policy which aren't necessarily opponents of race-conscious admissions, but proponents of using something different, such as socioeconomic status. One of the most famous on the progressive side, we'll go place not race, Cheryl Cashin, who is a law professor in Georgetown Law Center. Okay. So that's the race-neutral bucket. Only use race when race is the last resort. And the last one is the color-conscious bucket. And the color-conscious bucket says that, no, we need to use race. It rejects color blindness as both non-practical and nonsensical, and that we cannot not recognize race because race, even though a social construct, is real in America. It rejects race neutrality as simply a way to try to get to color blindness one day. And, you know, we do not need to only use socioeconomic status because that ignores a lot of the salience that whiteness holds today. It ignores such papers as Whiteness is Property, Cheryl Harris, that famous UCLA Law Review article. It ignores white privilege as it exists in America today. So the color conscious area was 100% a pro-race conscious bucket. It advocates the use of race to both increase this ominous term diversity and this is important outside the legal context, remedy the past effects and the current situations that those past effects create of racism, sexism, homophobia, etc.
Okay. Okay, so that's really helpful. And I'm wondering if you could also spend a few minutes, and there's obviously a lot of backstory here, but just a few minutes sort of explaining where we're at and what higher education institutions, what law schools are actually doing and permitted, really more importantly, permitted to do in the context of race-conscious admissions.
Okay. So we need to, unfortunately, go back to Richard Nixon, who really inherits the presidency because of the Vietnam War from LBJ. LBJ gave that famous speech at Howard that kind of started off affirmative action. And we go to a case called Regents of California versus Bakke. Prior to Regents of California versus Bakke, but a little bit after Brown, so I would say about 55 to mid-70s, 70s, universities were using race-conscious submissions and affirmative actions to try to diversify their classes, almost in an unmitigated way, unmitigated by the law. One such policy was the University of California Davis Medical School, which had a certain amount of slots. I think it was 18, it might have been 17, out of 100 reserved for what I call minoritized. Back then, they would probably call underrepresented individuals. Okay. Right? And there was a white individual, white male, called Alan Blocky, who had twice been rejected under this system. And he claimed that this was a violation of the Equal Protection Clause of the 14th Amendment, as well as Title VI of the 1964 Civil Rights Act. For your listeners that may not be lawyers, that may be mumbo jumbo, but it becomes important a little later on. So we had 9 justices on the court. We had a separate opinion. 4 justices who back then would be considered, I guess, conservative, but Justice Stevens was in that block, wrote one opinion. 4 justices that even today would be considered liberal wrote another opinion. And the opinion that won out, the opinion that became good law, was the sole opinion of Justice Lewis Powell. And this opinion said that you could not have a quota system, and since that day, quotas, set aside, or anything that even looks like a quota, Brian, is not allowed in college admissions. You cannot say that if, let's use a public school, the University of Massachusetts, we have 1,000 students to let in. We need to make sure that 100 of those students are African-American because 10% of the state of Massachusetts, I'm making these numbers up, are African-American.
Okay.
that is illegal or unconstitutional, because illegal is a kind of a different concept in the law. That would be unconstitutional. So since Bakke, quotas and Lewis Powell's sole opinion, quotas are unconstitutional. What is allowed, and what still is allowed today, is to use race as a factor for the purpose of increasing diversity in your classroom. So if you feel that the conversation in your classroom is in such that certain views, certain mindsets, certain experiences are not represented, then you can use race as a factor in your admissions policy for the purposes of affecting that conversation. That was kind of the law back with Bakke, but like I just said, that's not a majority opinion there. There are 9 justices on the Supreme Court. You need 5, as Justice Brennan famously always told us, to make law. Law was technically not made in the Bakke case, but everyone followed it as it was law. Fast forward now to the early 2000s, and you have a case that comes out of the University of Michigan, particularly the law school, which is Grutter. The court's composition has changed. It's, I think, identifiably more conservative. And many people think that, well, the question is, since Bakke was a 4-1-4 decision, is that even good law? And what is the current status of affirmative action? And in her opinion, and this is a 5-4 opinion, so it actually solidifies Bakke in 2013, Justice O'Connor solidifies the rule of Bakke and this diversity rationale, which I just described, as a compelling governmental interest for using race in college admissions. So again, Justice O'Connor does not go back to the time before Bakke and says we can use quotas. Quotas are still unconstitutional. But if a college can show that they need more students, and the language that comes out of Grutter, and this is very important for readers to understand, is the language of critical mass. A critical mass, or a certain number of students, in order for all students, not just the minoritized students which we're trying to recruit to get to this critical mass, but all students can get the educational benefits that flow from diversity. Those benefits were described in that opinion as reduced racial stereotypes, cross-racial interaction, et cetera, et cetera. So that comes out in Grutter in 2003. Let's fast forward again, because I know, time is limited. So we're going to skip a whole bunch of other political things and get to a case that actually started, ironically enough, in 2008. It was filed around the same time we elected our first Black president, President Obama, and that's the case of Abigail Fisher. So Edward Blum, who is a conservative activist against race-conscious admissions, recruited Miss Fisher, and Miss Fisher was in the University of Texas. And at this time, the University of Texas, for reasons I skipped over, has a top 10% plan, which the top 10% of every really public high school in Texas, if you were in that top 10%, got first admissions to any school in Texas. And of course, the marquee school is the University of Texas at Austin.
Okay.
However, after Grutter, with the top 10% plan still in place, because it's in there based on legislation, the University of Texas again started using race in the constitutional way that Bakke and Grutter allowed. So this factor of a factor of a factor. So with the Fisher case, and there are actually 2 cases, what both Fisher 1 and Fisher 2 are questioning was, if this top 10% plan, which gives you a certain amount of diversity, is necessary, why do you then need, and this goes back to the race neutral bucket, why do you then need to use race at all? You're getting some diversity, maybe enough diversity from the top 10% plan. Why do you still need to use race as a factor of this race neutral means the top 10% plan gives you this way? So the first Fisher case really didn't give us an opinion. The second Fisher case is one of the last cases on affirmative action, and Justice Kennedy, who actually dissented from O'Connor's opinion in Grutter, wrote, and he reaffirms the rule that started in Bakke, that was codified in Grutter, and now re-solidified in Fisher, that you can use race as a factor for the purposes of increasing the diversity rationale, increasing the diversity of conversation, of thought, of experience in college admissions. And that is the current law that public schools are under.
Okay.
Now, because of Title VI of the 1964 Civil Rights Act, I told your listeners this will become important later.
Yeah.
It's almost 99.9% sure that private schools, by virtue of taking federal dollars, over 90%, even at Harvard, of students take federal funds through federal financial aid, has to follow the same laws as our public schools. So really, this conversation we're having today should be thought, unless something changes drastically, to govern both private and public schools.
Okay. Okay. So if I understand it correctly, then the way the law stands right now is that schools can engage in race-conscious admissions in a limited fashion for the purpose of increasing diversity by reaching a critical mass of underrepresented or minoritized students. What is a critical mass?
And there, my friend, is the correct question. So there's been social science research on this. So a critical mass, and I wrote about this in my dissertation, comes from not legal language, it really comes from scientific language, right? You need a critical mass to get an explosion in quantum physics. You need a critical mass of a certain amount of business leaders in order to do, a certain deal. So, it's a quantitative measure that could only be measured qualitatively in the law. So, first of all, it's contextual. So what a critical mass, in order, and again, what really your listeners really need to understand is that the goal in and of itself is not a critical mass. A critical mass is necessary to get to the goal. So Brian, if you're really hungry, you've been riding all day, you've been doing podcasts, and you're trying to get home. And, you rush out of the office over there in Lexington, and you get to your house and you realize, damn, I don't have my key. Let's think of the critical mass as the key, okay? But the goal is food. You could just go down the street and probably get some food. The only situation in which would make you not having that key critical is if the only food in Lexington, Kentucky, for some reason, was in your house.
Okay.
So that's the situation that kind of exists. The food is diversity. The food is having an African-American Republican, so the students in a class can know that not all Black people are Democrats. The food is having an African-American that can speak in a criminal procedure class, so you can know, yes, I grew up in the hood, but I was not a gangster. That's the food, and the key to get into the door to get to that food, which has only existed in the house, is critical mass.
Okay. Okay.
So how do we get that key? What exactly is that key? Truly and utterly depends on the situation. Just like a key, there is no skeleton key for critical mass. It truly depends on the lock and the situation. So what critical mass is in Lexington, Kentucky will not be critical mass in Savannah, Georgia. Not be critical mass in Cambridge, Massachusetts. Will definitely not be critical mass in Los Angeles.
Okay. Okay. So I think I understand the sort of the instrumentality, as it were, of what's going on here a little bit better. And there was another dichotomy that you discussed in your dissertation that was really helpful for me in understanding the nature of what's at stake. And that's where you talked about the difference between structural and interactional diversity. And I was wondering if you could explain what the difference between those two is and sort of how that factors into how law schools are currently thinking about diversity, as well as how it ought to factor into how schools think about diversity.
Yeah, sure. So the concept of structural and interactional diversity really goes back to Sylvia Hurtado, who I think is still at UCLA, and Patricia Gorin, who was an expert witness in the University of Michigan Law School's case, as well as work by other people like Mitchell Chang as well. And the way I use it in the dissertation is I say, legally, The compelling governmental interest, Brian, and you'll appreciate that word, and the lawyers on your listeners will appreciate that word, is not critical mass. It's the educational benefits that come from critical mass. But critical mass, in and of itself, is necessary but not sufficient to get to those benefits. So what do I mean by that? Critical mass represents structural diversity or numerical diversity, or as my friend Carly Ford at Penn State has described it as cosmetic diversity. 100 people in a class, there are 10 Black people, 15 females, and the rest are white men. Okay, in order to increase our structural diversity, let's get 5 more African-American students of any gender, and it goes from 10 to 15. That's structural diversity, and that increase gives us an increase in structural diversity. However, if you read truly Grutter's decision, Baki's decision, and definitely Fisher, the legal goal is not structural diversity, but the legal goal is interactional diversity. Now here is where being an interdisciplinary researcher really comes in, and where I get really excited. The research, the education research says that any benefits that come from diversity, first you need structure. Meaning if there are 0 out of those 100 that are African American, we cannot get to interactional diversity. Now I'll get to what interactional diversity is in a second. So you first need, it's a necessary component to have that structural diversity, but it's not sufficient to get to the benefits that come from diversity. Again, cross-racial interaction, reduction of stereotypes. What you need to get to those benefits, Brian, is interactional diversity, meaning that you need students inside and outside of the classroom having cross-racial interactions, both academically and socially. Currently, the focus on affirmative action, race-conscious missions is on structural diversity and numbers, quantitative. What we are ignoring, and which is sad that we're doing it both on the conservative and the liberal side, is interactional diversity. What's actually happening on your campus right now that justifies you needing more African American students? What's actually not happening in your classrooms right now from the professor's standpoint that justifies you needing more African American students, more Latino students, more, Asian American students that happen to be of a certain sexual orientation? You understand? So that's interactional diversity. Are people of different views interacting with each other? Structural diversity is simply the numbers. So from 10 to 15 students, we have an increase in African American racial structural diversity out of 100 at a school. But then, are you measuring interactional diversity? What exactly are those 5 students adding to the conversation? Or are they being isolated? Are they not being called upon in a classroom? Okay. Are the white students not listening to them in a classroom? So you can increase structural diversity and have no increase in your interactional diversity.
Right. So if I understand what you're saying correctly, kind of in the broader paradigm, then is what you're saying is sort of the premise is that a lot of schools are using race-conscious admissions to, achieve some degree of structural diversity, which may or may not constitute a critical mass, however you choose to define that in context. But they aren't actually using that critical mass to achieve the benefits that could flow from that diversity. Is that
well, I don't want to condemn in a broad statement like that schools that might actually be doing it. I think I could say this without question, based on my research and based on the review of the literature. Most schools aren't doing it, and a vast number of the schools that aren't doing it don't even know that they should be doing it.
Okay. Excellent. Well, given the limitations on time and how interesting your actual study was, I think we should shift gears, and maybe you could talk a little bit about the actual qualitative study that you did. Sort of, what was the question you were asking? How did you conduct the study, and what did you learn through the study that you conducted?
So Little bit of context, because without context, I don't think qualitative research actually works.
Okay.
So I first began this kind of questioning way back in 2012, where I first started law school. And I eventually wrote a master's thesis upon graduating law school, to get a master's that I got with that degree about affirmative action. Didn't have to do with race. So I wrote about gender and sexual orientation affirmative action, which your lawyers will know go under a different test than strict scrutiny. I continued that research, and when I was asked to come up after I decided to get a PhD with a dissertation topic, I was no longer very much interested in critical mass, because I realized that was a morally bankrupt concept, or at least an intellectually bankrupt concept. I was very disheartened with the diversity rationale as a whole. And Harvard researcher Natasha Warrico talks about the way that the diversity rationale commodifies minoritized students in a way that's not productive and is crazily neoliberal. So what I wanted to know was, okay, let me take a school that is affirmatively using race-conscious admissions, which means that if it were ever sued, it would defend itself by saying, we are trying to get a critical mass. See that school admit a class through that process. Whether it's a critical mass or not, I was less interested in measuring that. What exactly happens at that school? So the research question was, how does diversity work at a predominantly white law school? So what I did is I observed the class. It was a 1L class on a topic that potentially could have some race conversations, criminal law. And I combined that data set with several hours. It came up to, over 100 hours of observational research. But I limited that observational research to in the physical building of this predominantly white law school. So I didn't want to move out and the case study to go into social settings. And the reason I didn't want to do that was I purposely wanted to know that if things were happening outside the academic building, that it's something that I may want to research, but was limited to research because that told me something about the academic building, right? What exactly things that students didn't want to happen in the academic building, or conversations that were happening outside the academic building and I wasn't privy to. So I showed some research discipline, and I limited it to the academic building and to the observation of this classroom and to interviews of the dean at this particular law school, her assistant deans, the admissions at particular law school, and many students as well. And predominantly what I found were three things. One, there's a lot of ahistorical thinking around admissions policies in a law school.
Okay.
What do I mean by ahistorical? Very few of the administrators, but also very few of the students. And what shocked me was even the most progressive students, whether they were minoritized or not, did not know about the culture and policy and history of racial exclusion at the school they were at. All the conversation around admissions was forward thinking. In 2020, we want to look like this. In 2018, we had this amount of structural diversity. In 2019, we want this amount of structural diversity. But there was very little conversation about, well, okay, can anyone here tell me, when was the first African-American admitted to Granite State University, which is the pseudonym I use for my school? No one knew. Not even the African-American students knew. One student told me straight up, Brian, and said, I don't even want to know, because that's just going to make my situation worse. So kind of like a blissful ignorance. So the ahistorical nature really stood out to me. Another concept that I'm developing that came out of there is what I call the relative proximate view of diversity. And it really complicates this situation of critical mass. And that's why I told your listeners critical mass is contextual. So what does the relative proximate view of diversity mean? It means that I interviewed in this particular school a lot of white students that visibly saw that in their classroom there were only 4 African Americans, whether it be male or female. But because this was the most diverse environment, education-wise, they had ever been in, they experienced that as a tidal wave of diversity, to use a word that was given to me.
Really?
Yes. Well, yes. And if you think about it, just from a human standpoint, so you're a great researcher and an excellent scholar and outstanding lawyer, but if you shut all that off, right? And you just say, well, if I, never saw Martians and I walk into a room and there are 15 Martians, how are you going to experience that room? And of course, I'm not comparing students of color at all to Martians. What I'm saying is that for a lot of white students, even when they get to law school, it's almost that which they are experiencing, that they haven't experienced anyone in the K through 12 level. We don't even have the time to get into that. They haven't experienced anyone at the undergraduate level. That's why we need policies like Fisher. And then when they've only experienced 2 or 3 in the law school classroom, they're like, oh, not only is this diverse enough, this might be trauma diverse. You want 5?
Yeah.
I'm used to 0.
And
that's a relevant, proximate view of diversity. And the other thing, since this is a legal podcast that I'll leave your listeners with, is that I realized that a lot of schools, and I won't indict the school that I did this research at, and I'll just keep it general and say a lot of schools are opening themselves up for legal litigation by only focusing on structural diversity.
Okay.
There are a lot of schools who admissions policies, and most of the time, the people that run admissions at law school are lawyers. They're not calling over to general counsel's office. They might have to in certain standpoint, but they know the law. They know Grutter. They know Bakke. They know Fisher. But they still focus, even using individualized review, on structural diversity. And there's no attempt, Professor Fry, to measure interactional diversity. And, some of it is laziness. Some of it is, this is too hard. And some of it is just a complete and utter misreading and misunderstanding of the jurisprudence that surrounds race-conscious admissions.
Right, because if I understand it correctly, I mean, in a sense, it's sort of the implication is that they're obligated to think about interactional diversity insofar as otherwise it's just they're not really even trying to achieve what they're supposed to be doing.
They're not living up to the compelling governmental interest. So, and again, for your listeners that are listening, I'm not advocating this. I'm now simply trying to educate on this. If you are using race in college admissions, you are using it. And the only constitutional way currently, and I would say with the change in the Supreme Court, definitely the only constitutional way going forward, that you can use race in college admissions is for the purposes of impacting the conversation in the classroom. That's the only way. Race is such an abhorrent classification that we say it meets strict scrutiny. And the only way you can use race, and again, unfortunately or fortunately, this is to benefit minoritized individuals or to hurt minoritized individuals. The only way you can use race is to impact that conversation in the classroom. So if your college, your university, your law school, your med school is using race and it's saying, yeah, we're trying to get a critical mass and we're measuring a critical mass, we have a definition of critical mass, but there's no effort to measure the impact in the classroom, you're giving these conservatives such as Edward Blum exactly what they want, and that's a target on your back.
Yeah, well, one of the things I really found helpful in your dissertation as well was the way you used kind of particular stories or anecdotes to illustrate some of the ideas you were talking about. And I was wondering if you could share like 1 or 2 of those that you think were maybe like particularly helpful in sort of kind of understanding the problematic, as it were, of interactional diversity.
Yeah, so at the particular school I did my dissertation, they have a class on higher education law, maybe education law more broadly, but this particular topic they were talking about this day was a higher education law topic. And this was not the class I observed, but there was an African-American female who, upon hearing about my research, sought me out and described to me a situation in which she was in a classroom. It wasn't a large classroom, maybe about 15 students. And there was an older white female someone she did not know personally. And this is key to my research methodology. And it's exactly what's going on. She did not know this person personally, had no desire to learn about this person personally, but it was a colleague. It was someone who, as far as she knows, one day will be a lawyer in one state of America. And they were discussing blackface. And for your viewers that don't know, blackface is the practice, Brian, of non-black people, whether it be white or Latino, putting on black paint to look like black people. And there have been several controversies about this. The University of Oregon Law had a controversy in which a professor did it. There was several schools that have had controversies about white fraternities and sororities doing it. So at this point, which was about a year, 2 years ago when this conversation was happening, it was well known that this was a sticky subject for certain minoritized individuals. And it was after the class where the student said that she refused after a while to engage in a conversation with this young woman. And I asked her why, and she gave me this quote that really stuck with me. And she said, "I am willing to argue with someone that disagrees with my ideas. I will not argue with someone that disagrees with my existence." And really what I took that to mean was there has to be a baseline of respect for me to even engage in a First Amendment legal type of argument. And this was early on in my research, and this theme kept coming up over and over again, not just for minoritized individuals, but for the Federalist Society. There weren't a lot of students that actively supported the President of the United States at this school, but for the few students that did, it was a lack of engagement in the classroom because they had predetermined, for good or bad reasons, that the person was attacking them and not their ideas.
So Dwayne, that's really super helpful. And I was wondering, sort of in closing, if you could make a few brief observations based on your research about sort of what schools can and maybe should do to think about engaging more effectively with achieving forms of interactional diversity in law schools.
Yes, well, thank you for that. So, well, let me say this. It starts to go back. Let's start at let's end at the beginning, right? The first two is accept my two premises as fact and start making policies from there. That if you think, and maybe you don't think, but if you think that racism, sexism, homophobia, let's stick to racism because we're doing race conscious admission, has an effect on society, then you should be crafting admission policies which show you think that. You understand? And then, you can't just, in your admissions policies, look for the students who have the indicia of a certain type of merit which only describes white supremacy. So there are some schools in America that are like, look, we care about diversity, we care about race as long as they come from Ivy League schools. We care about diversity, we care about race as long as they have a certain GPA and LSAT. Now, I do agree that as a predictor, there's a certain LSAT score that you don't want to admit a student because you don't want to put them in a particularly poor situation. But I don't agree with the mismatch theory of one Richard Sander and UCLA. And I think schools need to start thinking about the independent merit of diversity. The second thing I would really recommend for schools to do is think about intentional affirmative ways to increase interactional diversity. One way is simply surveying your faculty. There are many faculty meetings, Brian, that you attend and people will attend, and the things you talk about. Two things you can do. Simply have a conversation about what conversations, what perspectives, what views are not coming up in the classroom, whether that be a torch class or a contract class or, God forbid, a race class or a constitutional law class, because that's going to give your admissions people data to go out and justify why we need to increase structural diversity to impact interactional diversity. The other thing that faculty can do is kind of like a null curriculum review. And that's, what aren't we teaching at this school and why aren't we teaching it? Are we not including Cheryl Harris's Whiteness is Property as required reading in our property classes? If so, why are we not doing that? maybe maybe your property professors just don't agree with that concept. But many faculty have not had a conversation about that. And the last thing I will say is that you can do what a lot of deans in the country are doing right now, and that's, money talks. Set aside some money for your organizations, whether it be affinity or not, to actually interact. There was one law school that came out in my research that while they fund every organization on an equal setting, they have a certain pot of money that's set aside only for people to work in collaborative events across ideologies. The ACU with the Federalist Society, the Students for Trump, if your law school has that, with BALSA or LALSA or something else like that, the Christian Legal Society with Outlaw. And I think that actually not only shows that you really care about what's really important from the jurisprudence of Gerder and Fisher interactional diversity, but it shows and it tells people on the outside world and in the inside world in your law school community, this is what's important. A reduction, crossing over lines, and dialogues across difference. So I think if I had to only do 3 recommendations, those are the ones I would leave your listeners with.
Fantastic. Well, Dwayne, this has been a great conversation. I've learned a ton from reading your work and from talking to you about it. And I really hope listeners will check out more of your scholarship and that your dissertation will be widely available for people to read shortly.
No, thank you, Brian. Thank you. And again, I appreciate it. I find that you are an immense scholar. So any compliments that comes from a person of your acumen is really humbling and true. And I just do it for the work. And I hope that anyone that's listening to this, if you feel like contacting me, please do. It's a conversation that needs to continue just beyond certain parameters. So thank you again for the opportunity. I feel blessed.